Hey folks, James Brenio. In this video, let's talk about infant settlements. What is an infant settlement? How does it apply in Virginia personal injury cases, car accident cases, slip and falls, other premises liability cases? And so this video is intended to talk about that, and hopefully we can get some useful information to you. So when it comes to accident cases, unfortunately, sometimes children are hurt tragically, severely, sometimes not so severely. But accidents happen just like car accidents involving adults. Sometimes children are hurt. Sometimes they're hurt at school. Sometimes they're hurt at a business. Sometimes they're hurt at somebody else's house. And so you end up with your mom or dad or somebody else that has custody of the child, end up having to make an insurance claim on their behalf. Now, the reason this is because minors, people under the age of 18, they can't enter into contracts themselves. So if you're seeking an insurance settlement from an insurance company, even if you reach a fair settlement, because they're under 18, they can't enter into that contract. And just a little caveat, typically speaking, when it comes to injury cases here in Virginia, you as an adult, you have a 2-year statute of limitations to file a lawsuit. Now, there are other instances like claims against the county or the Commonwealth where there are other timelines even before that you have to meet. But generally speaking, there's a 2-year statute of limitations. When it comes to minors, their statute of limitations actually doesn't start to run until they turn 18. So they're no longer under legal disability or incapacitation because they're over 18. If they're under 18, again, they can't enter into contracts. And typically because of that, their statute of limitations doesn't run until they're 18. Now, that being said, oftentimes you're going to be bringing if I'm an attorney representing a minor, I'm going to be bringing a personal injury case on their behalf much sooner because let's say the child is 5 years old, waiting 13 years to make a lawsuit or to make a claim oftentimes can be detrimental to the claim. Evidence is lost, witnesses are lost, time can make cases more difficult to pursue. So oftentimes you or I, the attorney, will be pursuing a case when a child is still a child and they're under 18. And so if I pursue that case and I'm able to reach a fair settlement with an insurance company, because that child is under 18, oftentimes we will seek an infant settlement where the parent or the guardian will go into court on the child's behalf to seek approval from the court. That way you get a court's blessing. So because they can't enter in a contract, but if you get court approval, this is the benefit. This is how you go about that process. Now, just to be clear, the reason that you get court approval or infant settlement is the court, and frankly, every party involved essentially wants an objective review on the case to make sure that the case is in the best interest of the child. Because what you don't ever want is a situation where, let's say you settle a case when the child is 12, they turn 18 and they realize, you know what, this wasn't fair, or an attorney or a parent or an insurance company takes advantage of a minor and they end up reaching a settlement that's not in the child's best interest. So the purpose of infant settlement, the purpose of seeking approval by the court, is for the best interest of the child. And essentially what will happen is the insurance company will typically file a petition, essentially get the case in the court, to get the court to review the file and to review the case. And the court will appoint what we call a guardian ad litem. A guardian ad litem is a separate attorney that's appointed specifically to the child. Their goal is not the interest of the plaintiff's attorney or mom and dad or the insurance companies. It's really to essentially do their own objective review of the case in order to essentially create a report for the court for their suggestion about whether or not this settlement is fair or not. And guardian ad litems typically have a lot of experience in infant settlement cases, so they're coming at this with experience that was going to be useful for the court in reviewing these claims. Now, again, the guardian ad litem will make an independent assessment about whether or not they think it's fair and best interest of the child. They'll also make sure that it comports with law, with Virginia law, to make sure it's fair and that it abides by the law. Sometimes, a plaintiff's attorney may not get a fair settlement, or sometimes an insurance company will be taking advantage of an individual, of a minor. And so the guardian ad litem is there to ensure that everything is above board. But that being said, typically speaking, I don't find that guardian ad litems will typically nitpick. Their goal is not, I don't think, to really get in the weeds of the case necessarily to say, oh, there should have been $300 more settlement, or whatever the case may be. I think they're there to really get broad points, to make sure the broad points are looked after. I don't think that they want to essentially Monday morning quarterback a case. So, for instance, let's say we've got a premises liability case where we're settling a claim for $75,000. A jury might award $150,000, but there's a liability issue where we may lose at trial. Typically speaking, at least in my experience, if I'm talking to a guardian ad litem and they say, well, the settlement number should be higher, and I tell them, look, I'm concerned about liability. I think so long as I've got a rational basis as an attorney to recommend that, and why that's in the best interest of the child, because getting $75,000 is better than zero, rather than risking it all for the $150,000. I think most guardian ad litems will understand that, and again, they're looking for the huge issues with the case, not strategic or subjective reviews of what's the right tact for a case. And the guardian ad litem will produce a detailed report for the court to review, and it typically will talk about the case itself. And in order to get these reports, by the way, the guardian ad litem will reach out to the clients themselves, to mom and dad, to the minor, assuming the minor is in a position where he or she can communicate to the guardian ad litem. And the guardian ad litem will be asking very straightforward questions. Do you understand the settlement? Do you understand where the money's going to go? What investments you're looking at? How is their physical recovery? Those kinds of things. So if you are a parent looking at possible settlement for your child, expect the guardian ad litem to reach out to you to ask very straightforward questions, basic questions about the case. But that's not a bad thing. That's a good thing, because having an independent review on a case is a good thing. Now, ultimately, the court will decide whether or not it approves a settlement. Again, I think in a lot of ways, like a guardian ad litem, I don't think that, at least in my experience, the courts here in a Monday morning quarterback, again, I think it's looking for the big bullet points to make sure that fairness is happening. I think they will take a little more liberty to step into the case than the guardian ad litem would, because that's ultimately their job. They may have very serious questions to ask. But again, I don't think their job is really to say, hey, you have to risk going to trial if there's a possible liability issue, versus settling for a particular amount, so long, again, as we can give a reasonable basis why that's in the best interest of the child. And when I say reasonable basis, by the way, I'm using that really as kind of not a legal term, but kind of my own characterization of it. So the other thing is, unless it's a relatively small number, we're talking about $5,000, $10,000, the court will typically not just hand the money over to mom and dad. They're typically looking that the money either goes to the clerk of the court, where it's entered into an interest-bearing account, so it's at least obtaining some interest, or they're looking for some type of fair and reasonable and reliable investment vehicle, such as an annuity, Virginia 529 plan, something like that. Now, you may have some other type of investment plan that you're interested for your child. That's something that you'll want to talk in detail with your attorney about, talk in detail with your guardian ad litem about, so they can give their input and feedback on that. But ultimately, the goal here is to make sure the money is safe, so when the child turns 18, whether it's being paid by an annuity in a structured settlement or going for education, it's still there. The worst case scenario would be that when the child turns 18, that the money's gone. So that's the reason, while mom and dad typically have the best interest at heart for their own child, it has happened where mom and dad spend the money, or they put it into a crazy investment, and all of a sudden now the child doesn't have the money. So that's part of the reason that the court is looking, not unless it's got good reason to just hand the money over to mom and dad. They'd rather have it in a situation where there's going to be definitely the money there, but also a fair understanding that there's going to be a return on that investment. Now, where the money goes, again, this is going to be case specific, and what your desires are for your child will really depend on your reasoning. Structured settlements and annuities, so long as they're in these high AAA bonded companies where we're pretty sure that they're not going to go bankrupt. Um, uh, but if your child is close to 18, though, it may be a very different decision, right? If your son is 16 years old and 2 years isn't going to do a whole lot in a structured settlement, the court may very well be fine with it. Just go to the clerk of the court. That way, it's simple. If you have other basis or other locations, then again, that's something to talk with your attorney or guardian ad litem about to try to get more information about that. But typically speaking, the older the child is, the quicker the money is to come to him or her. It may very well be best to put the money into the clerk's account. That way, it's there and it's going to come back quickly. Now, if you put the money in an account that's not like, say, a structured settlement where it cannot be moved, let's say it's in the clerk of the court's accounts, there are ways to seek the money before the child turns 18 for compelling reasons, education, medical needs, those kinds of things. You can petition the court to ask them to have the money released for specific purposes. My suggestion always is don't do this unless it has to be done. But I get life happens as well. So that's the reason there is some flexibility there if needed. Now, as far as, again, going back to where the money's going to go, again, a lot of different variables here, a lot of different things to look at, a lot of different financial plans, investments, and things like that. So it's going to be case specific, and it's going to depend on the age of your child, and also maybe even your own financial savvy. Maybe you're more savvy about investments than, say, I would be. So you've got different ideas. But again, that's going to be something you want to talk to the guardian ad litem about, and be prepared to talk to the judge about, the court about, if it's a complicated investment. Now let's talk about how the actual infant settlement hearing goes, because what happens is that a petition is initiated. You work with the guardian ad litem to prepare a report, and then you ultimately set up a hearing. Usually there's going to be in person in court. As we're sitting here December 2nd of 2022, we're coming out of COVID, at least the world's pretending we are. And over the last couple of years, we were able to do a lot of these infant settlements by Zoom or by WebEx. So it was virtual. Now it's in person for the most part. You got to come into court. But I will tell people, look, so long as the settlement is well thought out, it's likely not going to be a very stressful hearing. In fact, a lot of times it's very pleasant. The judges know, especially if they're dealing with a minor, how to deal with minors and, make jokes, make them feel less stressed. Just be prepared to answer basic questions. The judge is going to want to hear from you, the family, directly, that you have a fundamental understanding of what the settlement is, where the money's going, how that's all working. Also, likely want to hear from your injured child to make sure physically they're recovered. If they're not, what's the status of things, to get more information. They really want to lay eyes on, in a lot of ways, lay hands on, but, just as a saying, but they want to make sure that they're not just rubber stamping a settlement. And again, the court will be asking, you can't expect them to ask basic questions about the settlement to make sure it's fair. Also, if, let's say, for the guardian ad litem's report, there are questions that are not answered that haven't been addressed, the court will ask those as well. So just keep that in mind. And the court's also going to want to make sure that, let's say there's health insurance reimbursements, there's outstanding medical bills, those have all been accounted for. Typically speaking, when I'm representing somebody in settlement, I'm wanting to make sure that I've already identified all the health insurance liens. If there's outstanding bills, I've identified those. And from the settlement, I'm going to tell the court that, look, I'm going to pay those directly from the settlement. So there's no question about bills being owed later on. So be prepared to have an understanding of what the bills are, and all that. When you're preparing for your infant settlement hearing, you're obviously going to be working with your attorney. You're going to be talking to guardian ad litem. You also want to understand what the final order is. That's essentially the final document that the court approves and puts it on paper. And if there's other settlement documents, you're going to be reviewing that with your attorney beforehand. You don't want to just walk in the court not having read these documents. You want to have an understanding of that. So there's no question. So the attorney should be giving these documents in advance of the hearing. So that way, if you have questions, you can raise those questions and there's no confusion or mistakes. Again, make sure you've asked your attorney all the questions that you have. If there's questions that they haven't done a good job answering, or again, you just have more questions, make sure to ask your attorney. I always tell my clients, look, there are no dumb questions. if you're not understanding something, it's likely because I'm not doing my job well. So if you're still left with questions at the hearing, that's not good on me. So make sure if I'm representing you to ask questions, ask all you need. I also find guardian ad litems can be very useful resources. Typically speaking, guardian ad litems that we've worked with before. I trust most of the guardian ad litems that are up here in Northern Virginia that are approving cases. A lot of times they can be useful for practical things like, do you have a recommendation on a structured settlement company? How do you petition the court to get the money out? Logistically, what are things that this judge is going to be looking for? That kind of thing. They usually have a lot of good experience. So guardian ad litem could be super useful. The other thing is, typically speaking, I think I spoke about this earlier, it's usually going to be the insurance company, the party that is going to be paying the money that files a petition, pays for the petition, pays for the guardian ad litem. So that's a good thing as well. And another quick thing is, while typically speaking, an accident, if you file a lawsuit for an accident here in Virginia, you're going to file it in the jurisdiction where the accident happened. So let's say the car accident happened in Fairfax. When you file a petition for review for infant settlement, it doesn't matter which jurisdiction, so long as it's a circuit court here in Virginia and a circuit court judge that's approving it. So many times we will file in different jurisdictions depending on how backlogged the courts are. If Fairfax got, I know that I'm not going to get a hearing for 6 months, but I know that if I can go to Loudoun and get a hearing in 3 months, we're going to go to Loudoun because it's usually the most efficient way to do that. So just something to think about. There's variation that can be done there. So look, I hope that this video has been useful. If you're involved in an infant settlement case, first of all, if one of your children have been hurt, I just want to say I'm sorry that happened. I'm sorry you're going through that. That I can't imagine as a new parent how stressful that may be. But think of the infant settlement process as a good thing. You want to be in a position where you have as many eyes on the case as possible. That way you can feel the most confident you can about making sure that the settlement's fair and that it's in the best interest of your child. I know this stuff is new. If you don't know about court, that's a good thing, but you should not have to deal with it before. So be prepared to ask your attorney questions. Hopefully this video is useful. Maybe it sets some the stress level a little bit low if you've got an infant settlement coming up. Now, that being clear, if you have an attorney representing you and you're just watching this for educational purposes, make sure that if your attorney is giving you contradictory statements and advice, you hired them for a reason, so you got to rely on their advice. But if you have an infant settlement, you should be hiring an attorney to help out because this is complicated. So wish you guys the best. I'm going to throw up my information up here real quick. Here's my phone number, my website. So go there and check out. We've written a bunch of articles. We've shot a bunch of videos. Also subscribe to this YouTube channel. We're constantly updating it with new and useful information. So I wish you guys the best. Until next time, stay safe.